contacting them or talking to them, I get that, like sitting in your car and watching them. But if I were you, I'd walk. If I was going out my front door, get in your car and leave if you're going somewhere. No lingering, no looking that direction, no standing there watching. That's going to be of concern to me. That's with Miss Malfino. Good morning, sir. You're Dan Church.
Oh, yes, ma'am.
And this is 26 DCCR 0612. Mr. Church is charged with deadly conduct, discharging a firearm. And the state has filed a motion asking that, well, I'm looking at the state's motion. The motion it says aggravated assault, but the charge is deadly conduct. That just
I'm sorry, Judge. That's my error. I was
Okay.
trying to file it rather quickly after receiving the affidavit from the complainant, and I'll fill the court in on that as to why I don't have a witness present.
It looks like the current bond is set at $20,000. The state has asked to raise that bond. Ms. Malfino?
Excuse me, Judge, and I apologize about that error. Obviously,
That's fine.
the court would see the probable cause affidavit. It's very similar to an aggravated assault, discharging a weapon somewhat in the direction of the complainant. In this case, I have had multiple conversations with Jeremy Shelton, the complainant. He is the across the street neighbor of Mr. Church. He is a very nice young man. He was very forthright, came in and presented me or had an affidavit authored by himself with one of my investigators in lieu of coming to docket today. He, as the court can probably surmise, is of the mind that he doesn't want to aggravate the situation. Nope, not intending to use that same word, but I will tender that as State's Exhibit number 1, just for purposes of this hearing. And I have Mr. Gertz. It's his affidavit just expressing concern about the nature of this offense and the fact that they reside across the street from one another, that he has a very young son and a wife who were also present at the time of this offense. And he has concern that Mr. Church may be keeping weapons at his sister's house down the street. I have worked very closely with my investigator, Mr. Bays, and he is familiar with Mr. Church as well as Port Arthur Police Department is. And we've asked that some things be implemented in the interim time period to hopefully assure the safety of all the parties, including Mr. Church. I just wanted to bring this matter to the court's attention with that motion. It's not necessarily intended to increase as much as it is to modify with the admonishment regarding weapons, etc., because obviously it's difficult to remove these two individuals from one another approximately because of where they both reside.
Any objection to me reviewing that?
Well, Judge, the rules of evidence don't apply in a bond hearing, so I would love to have some great evidence, but I don't have a good one.
And I'll state the ones admitted for purposes of this hearing. Give me just a second, please. Mr. Gertz?
Judge, I'm happy to discuss bond conditions. $20,000 is more than sufficient, though, in terms of the amount for this allegation as it stands right now, or as it's indicted right now. Mr. Church wouldn't, I think, object to the normal conditions of not having any contact with the complainant, not possessing any weapons.
Those are already conditioned.
Right. I'm not sure what else, what else the court could impose, because of the proximity of their homes without infringing on his constitutional property rights of his own. But I think the fact that he's, hired counsel, has shown up to court, he's taken this seriously. He's not been threatening the complainant or anything of that nature. I understand the complainant may have concerns, but those are the complainant's concerns. They're not being triggered by anything, no pun intended, by anything that Mr. Church has done since his arrest or his indictment. And so, and he's not violated any of his bond conditions that
I think
that I'm aware of, or that
is if they feel like he is watching, could be, just uncomfortable. There's an allegation that he's sitting in his car watching family, obviously based on the nature of the offense and the allegations and the probable cause. That would give me some concern too if I lived across the street and that had actually happened. So,
but I don't think I just don't think raising his bond and just charging him more is the proper remedy for that. So I'm not sure how the court remedies that. I don't see
the way it gets remedied, Mr. Church, is if you're doing anything that's making the person uncomfortable, that's the complaining witness in this case, the only way for me to take care of that is to put you in jail. Then they don't have to, nobody has to worry. I don't want to do that. But I need you to understand that there's no way around if, you know, you're not contacting them or talking to them. I get that. But if you're doing other things, like sitting in your car and watching them, then that's going to be of concern to me. So I'm ordering you. Here's what I'm ordering right now. Listen to what I'm going to say very clearly, okay? This no contact order is going to include literally looking that direction. You can't sit on your front porch. You need to sit in the back. You can't just sit in your car for no good reason. People don't do that. So you're not going to do that. Do you understand?
Yes, ma'am.
So if they feel uncomfortable, they're going to let Miss Malfino know, and you're going to end up in jail. So I understand you live across the street, but if I were you, I'd walk. If I was going out my front door, get in your car and leave if you're going somewhere. No lingering, no looking that direction, no standing there watching. Otherwise, you're going to end up in jail because I won't have any other choice. Does that make sense?
Yes, ma'am.
Okay. So we'll reset this for an announcement. Make sure you stay in touch with Mr. Gertz, visit with him before that next court date, and we'll see if we can get an announcement. Okay.
Yes, ma'am.
You're free to go.